Welcome to this week's 2-Minute Tuesday briefing. My name is Matt Harkins and I'm an associate attorney at Inman Kaminow. I'm here today to talk about some common myths within the DC workers' compensation system. The first myth is that if the injury is your fault, you cannot file a workers' comp claim. This is not true. DC workers' compensation system is what's called a no-fault jurisdiction, meaning that if the injury is 100% your fault, you likely can still file a claim. I say likely because there are some exceptions to this general rule, but overall the vast majority of injuries that are your fault are still accepted as long as they happen at work. Myth number 2 is that if you get hurt at work and you file a claim with the insurance carrier, you don't have to file a claim with the DC Office of Workers' Compensation. That is not true. In order to have a claim, you must file with the DC Office of Workers' Compensation. Myth number 3 is that workers' compensation benefits you receive are taxable income. Great news, that's not true. However, when you're filing your taxes and you have any doubts or questions about this, recommend that you consult a tax attorney. Myth number 4 is that the insurance company is always looking out for your best interests when it comes to a workers' compensation claim. This is not true. Typically, insurance companies are trying to minimize their costs when it comes to a workers' compensation claim. That's why we recommend that you retain counsel from Inman Kaminow, because Inman Kaminow attorneys will always be looking out for your best interests. Myth number 5 is that filing a workers' compensation claim means the same thing as suing your employer. That is not true. Filing a workers' compensation claim does not mean that you are also suing your employer. In fact, if you file a workers' compensation claim, you are not allowed to sue your employer for the injury as well.